Let's take a look at who is entitled to FMLA. Leave policies are one of the major ways in which the work-life conflicts of employees can be addressed. What does the law require in terms of leave policies? The Family Medical Leave Act, known as the FMLA, is the main federal law governing the provision of leave for employees for parental or medical reasons. All government agencies, regardless of their size, are covered by this law, as are private sector employers with at least 50 employees. The FMLA provides a minimum standard for the leave policies of covered employers. Parental and medical leave policies must be consistent with the provisions of FMLA outlined here, although employers are free to exceed the law's minimum requirement. Entitlement to FMLA leave depends on a number of factors, including the size of the employer, the duration of the employee's tenure with that employer, the number of hours worked by the employee in the 12 months before the leave. Leave is also granted based on the occurrence of a qualifying event for which the leave is needed, and provision of adequate notification to the employer of the need for the leave. The employment duration and hours requirements must be met as of when leave would commence rather than at the point in time which leave is requested. So, an employee cannot be deemed ineligible for leave that would commence in the future simply because the duration or hours requirement is not currently met. In a case involving a part-time radiological technician, the court allowed the employee's FMLA claim to proceed even though the employer's timesheets showed that she had worked about 65 hours less than the 1,250 hours required. The reason was that she could show that the time spent each day prior to her shift preparing equipment for use and the time spent at her employer-mandated continuing education courses were work hours that should have been counted. In contrast, a mail handler worked 1,248.8 hours in the preceding 12 months and was lawfully terminated for absences that might have been covered by the FMLA. Her argument was that a 2-hour suspension administered a month before her termination should not have been considered and was rejected because she had failed to file a timely grievance challenging the suspension. Tallying the number of hours worked during the past 12 months is not always a straightforward proposition. An employee who is otherwise eligible for FMLA leave must still experience a qualifying event to be entitled to take the leave. Qualifying events include the birth of a child of an employee, placement of the child of the employee by adoption or foster care, the need for the care of a spouse, child, or parent with a serious health condition, the inability to work due to a serious health condition, the need to care for a service member, and any qualifying emergency due to a family member on active duty. FMLA does not include time off for other family-related activities, such as attending parent-teacher conferences or obtaining counseling for marital problems. Both males and females are entitled to parental leave. Entitlement to parental leave under the FMLA generally expires 12 months from the date of birth, adoption, or foster care placement. If an expectant mother's medical condition warrants that leave begin before the birth of a child, such leave is available under the qualifying event of a serious health condition. The definition of a serious health condition is complex. The term is far more inclusive than disability, but it still does not encompass all medical problems of an employee or a family member. Basically, a serious health condition is a medical condition that involves either inpatient care in a hospital or continuing treatment by a healthcare provider. A serious health condition involving inpatient care includes not only the actual period of hospitalization, but also any period of incapacity and time needed for subsequent treatment of the condition. Serious health conditions involving continuing treatment by a healthcare provider include the following: conditions that result in periods of incapacity of more than 3 consecutive calendar days and either 2 or more treatments by a healthcare provider. Any periods of incapacity relating to pregnancy or prenatal care. Any periods of incapacity, including subsequent treatment due to chronic, serious health conditions for which at least 2 visits to a healthcare provider are made per year. Long periods of incapacity due to conditions for which treatment may not be effective. Any absences to receive treatments from healthcare providers for conditions that would likely result in periods of incapacity of more than 3 consecutive calendar days if left untreated. Ordinarily, unless complications arise, the common cold, the flu, upset stomach, headaches, and other migraines or potential diseases do not meet the definition of serious health condition and do not qualify for FMLA leave. Although these are useful examples, ultimately the criteria to determine the existence of a serious health condition can be confusing. Not surprisingly, the existence of a serious health condition is sometimes disputed and must be decided by a court. The right to take leave for a serious health condition of a family member is limited to immediate family. Employers are not required to grant leave so that employees can provide care to grandparents, aunts, uncles, or even in-laws. A person taking leave based on a serious health condition of a family member must actually provide physical or psychological care. Employers may require that requests for leave based on serious health conditions be supported by certifications from healthcare providers. Employees must be given at least 15 days to obtain this medical documentation. The process of documenting a serious health condition should not be onerous, and the information provided by an employee's own doctor should generally be sufficient. When the information provided is deemed inadequate, employers are required to notify the employee in writing, indicate which information is missing, and afford the employee at least 7 calendar days to provide the information. Employers may contact employees while they're on leave to receive information on their status and verify their intent to return to work following the leave. Employers are also permitted to require medical certification of fitness upon an employee's return to work, provided that this is the employer's general practice. An employer violated the FMLA when it overruled a doctor's assessment that an employee with several fingers splinted could nonetheless perform her job, which included typing, without restriction. It is the job of the healthcare provider and not the employer to determine whether the employee is fit to return to work. Employees are responsible for notifying their employers that a qualifying event has occurred for which leave is needed. This notification can be verbal and need not specifically refer to the FMLA, but it must provide enough information to alert the employer that the FMLA might apply. Calling in sick by itself is not sufficient notification. If the need for leave is foreseeable, such as a birth or planned medical treatment where at least the approximate leave dates are known, employees can be required to provide 30 days advance notice. Failure to provide adequate notice when the need for leave is foreseeable can result in delay of the leave until the 30-day notice requirement is satisfied. If the need for leave is not foreseeable, such as when a serious health problem emerges suddenly and without warning, employees are responsible for providing notice as soon as practicable. The DOL expects employees to comply with their employer's usual and customary notice and procedural requirements for requesting leave absent unusual circumstances. But with serious medical emergencies, notification might be made during or possibly after periods of absence. Likewise, employers' requirements for written notification of the need for leave cannot be enforced in emergency medical situations. When leave is needed for planned medical treatment, employees should consult with their employers regarding the timing and attempt to schedule a less disruptive time. The FMLA requires that employers provide the following to eligible employees who experience qualifying events: up to a total of 12 work weeks of leave over a 12-month period, when the qualifying event is the serious injury or illness of a service member incurred during active duty. The maximum period of leave is extended to 26 weeks. Maintenance of health insurance under the same conditions as if the employee had not taken leave. Restoration to the same position held before leave commenced or to an equivalent position with the same pay, benefits, and other terms and conditions of employment. These three core requirements reinforce one another. The right to take leave would be rendered meaningless if employees did not retain their health insurance. Likewise, the promise of a right to take leave would be illusionary if employees had to take leave without a reasonable guarantee that their jobs would still be there upon returning from leave. These employee rights are supported by requirements that employers must refrain from discriminating against employees for taking FMLA leave and from otherwise interfering with, restraining, or denying the exercise of FMLA rights. Generally, employer actions that delay or deny the leave give rise to interference claims, while actions taken by employers during or after periods of leave to punish leave takers constitute retaliation. Although both violate the FMLA, the distinction between interference and retaliation is important because a legal motive must be shown in retaliation claims, while the employer's reasons for interfering with FMLA rights do not matter. Decisions adversely affecting employees who've requested FMLA leave, who are on leave, or who have recently returned from leave should be very closely scrutinized. A common issue in FMLA cases is employees being disciplined or terminated based on absences due to FMLA leave. Employers must not base adverse employment actions on the taking of FMLA leave. The FMLA creates an entitlement to leave. If an eligible employee experiences a qualifying event and notifies her employer that she needs to take leave, the employer must grant the amount of leave needed. Employers have four options for determining the 12-month period. It could be the calendar year, any other fixed 12-month period, a 12-month period measured from the first day of leave, or a rolling 12-month period. The latter two methods are more complex but prevent employees from stacking periods of leave on top of one another. Employers must adopt one of these methods and use it consistently, and notify employees regarding of their choice of method. Although employers can require employees to comply with reasonable policies applied to ensure that leaves are not being abused, employers are not free to assign work duties to employees on FMLA leave. Depending on which qualifying event necessitated leave, it may be taken consistently or continuously or intermittently, which consists of period of leaves mixed with periods of work. Leaves for childbirth, adoption, or foster care placement must be continuous unless the employer allows otherwise. Leaves for serious health conditions of employees or family members can be either depending on employee need. A critical issue for employees is whether the time off from work comes with pay. Under the FMLA, employees may choose or their employers may require them to substitute available paid leave for unpaid FMLA leave. Any paid leave that is substituted must fit the qualifying event that necessitated FMLA leave and any other neutral requirements of the employer's normal leave policy. The FMLA specifically requires that health benefits be maintained under the same conditions that would pertain if the employee did not take leave, such as the coverage level and employer contribution. On return from FMLA leave, an employee must be restored to the same position held when the leave was taken, or to a position that is equivalent in pay, benefits, terms, and conditions of employment. Taking leave does not immunize an employee from a layoff or termination that would have occurred anyway. There is a narrow exception to the restoration requirement when a key employee takes leave. A key employee is salaried and among the top 10% of the company's earners. They must be informed of their status when they seek leave. If the employer decides that their restoration would cause substantial or grievous economic injury, they should be given a reasonable amount of time to return from leave. Employers presented with requests for time off related to parental or medical issues must carefully consider whether the leave is required under the FMLA and respond promptly. The FMLA envisions a cooperative dialogue, a real interactive process between employers and employees through which a balance of needs can be struck. Most litigation arising under the FMLA results from a breakdown of that dialogue. However, this dialogue must proceed from the basic premise that employees have an entitlement to leave under the FMLA. Generally, employers do not have the right to deny or to delay FMLA leave. Thus, a court held that an employer's effort to get an employee to delay a continuous period of leave until a less busy time could constitute interference with FMLA rights, even though the employer subsequently relented. The DOL regulations call for employers to provide written notice to employees requesting that the leave is being designated as an FMLA leave, generally within 5 business days after notification of the need for leave. The Supreme Court has said that the DOL cannot punish employers who fail to provide timely notification by not allowing them to count the days of leave against an employee's maximum entitlement, but their basic principle remains. Employers are responsible for promptly designating leave as FMLA leave and for informing employees of their rights under the FMLA. The DOL has forms that employers can use to provide the required notices, and employers should generally use them. Because of the relatively high employer size threshold for coverage under the FMLA, many employees do not receive its protection. In light of limited coverage of the FMLA, the Pregnancy Discrimination Act continues to have a significant influence on leave policy. The PDA confirms that discrimination based on pregnancy, childbirth, or related medical conditions is sex discrimination and violates Title VII. The PDA does not require that employers provide leave for childbirth or medical problems associated with pregnancy. However, employers must treat persons with pregnancy-related conditions in the same manner as persons with other medical conditions who are similar in their ability or inability to work. If sick leave, disability leave, or other forms of paid or unpaid time off are available to a company's employees, the same forms of leave and the same terms must be available to its pregnant employees. If an employer accommodates employees unable to work their usual jobs with measures like light duty assignments, the same accommodation should generally be available for pregnant employees. Pregnant employees are entitled to continue working for as long as they can perform their jobs, except in those rare cases where not being pregnant is a bona fide occupational qualification. Employers are prohibited from requiring pregnant employees who can perform their jobs to take leave or from establishing arbitrary timelines when parental leave must commence or end. Pregnancy-related conditions cannot be singled out for special procedures for determining ability to work. However, any medical certification that is generally required before granting leave or for documenting fitness for duty on return from leave can also be required of employees who take leave for pregnancy-related conditions. Jobs must be held open for employees on pregnancy-related leave at least as long as they'd be held open for employees who take sick or disability leave for other medical conditions. As citizens, employees are sometimes called on to perform duties that require their absence from work. One example of this kind of duty is serving on a jury. The Federal Jury Systems Improvement Act protects persons who serve on federal juries from discharge, intimidation, or coercion by their employer. Most states also have laws protecting from employee discharge who serve on juries. Some states require that employees be paid while on jury duty. Voting is another civic duty addressed by state law. Most states require that employees be given a specified number of hours, generally 2 or 3, off to vote when there is not sufficient non-work time to do so. Most often, the laws specify that this is paid time off, but allow employers to determine the particular hours to be used for voting. Thus, although the details vary between states, employers must generally provide employees with time off to serve on juries and to vote. The Uniformed Services Employment and Reemployment Rights Act, known as USERRA, confers numerous rights on employees who engage in military service. Employers of any size are prohibited from discriminating against people who are members of, apply to become members of, or have obligations to serve in a uniformed military service. Often, complying with this law simply means allowing the employee in the National Guard to attend scheduled annual drill training and treating the employee as if they had not been absent. But at a time when National Guard members and reservists are regularly called upon to serve lengthy deployments to other countries, employers must be aware of USERRA's enacting requirements regarding restoration from military leave. As a general rule, employees are entitled to reemployment following up to 5 years of cumulative absence, not counting periods of required training for military service. An employee taking leave for military service must notify his employer to this effect, but is not required to await permission or to decide at what time whether reinstatement will be sought following the period of military service. Provided that an honorable discharge is received and a timely request made for reemployment, an employee returning from military service must be reemployed. Service members have to report more or less immediately following service periods of less than 31 days and within 90 days of discharge when the service period exceeds 180 days. Service members who become injured or disabled during service are given up to 2 years to return to their job. The main exceptions to reinstatement requirements are when reemployment is impossible or unreasonable, the necessary training would impose undue hardship, or prior employment was temporary. Under the escalator principle, employers must attempt to place individuals returning from military service into positions, including promotions, that they likely would have attained absent of their service. The principle applies even when managers retain significant discretion in deciding whom to promote. Employers must make reasonable efforts, such as by providing training, to permit returning service members to perform their job. If individuals are not qualified to perform the jobs that they would otherwise have attained, reinstatement to the position held prior to military service or an equivalent position must generally occur. Reemployment under USERRA also means that an employee returns with the seniority he would have had if he were continuously employed and any other benefits related to length of service. Benefits unrelated to seniority must be maintained on the same basis as for other employees receiving comparable non-military leaves of absence. The EEOC defines national origin discrimination broadly as the denial of equal employment opportunity because of an individual's or their ancestors' place of origin. Discrimination can also happen because an individual has the physical, cultural, or linguistic characteristics of a national origin group. Courts have sometimes found animus towards employees who speak with accents to be direct evidence of national origin discrimination, but most courts do not go that far in equating linguistic and national origin discrimination. An employee or an applicant's accent can be lawfully considered in making employment decisions when communication is a significant part of the job in question and the individual's accent substantially interferes with the ability to communicate. The critical issue is comprehension rather than the person sounds different or foreign or that understanding the person requires extra effort on the part of listeners. Fluency in English should be considered only to the extent that it is job-related, as this selection criterion is otherwise a strong candidate for adverse impact claims. The linguistic demands of jobs can vary widely within the same organization, making it important to distinguish between positions when establishing fluency requirements. Employers with bilingual or multilingual employees sometimes institute English-only rules that prohibit or restrict the speaking of languages other than English in the workplace. These policies vary in breadth, from total bans to time and place restrictions on when other languages can be spoken. The impetus for establishing these policies is often the complaints of monolingual English-speaking employees who believe they're being denigrated. Safety concerns, customer preferences, and problems in supervision are also cited as motive. In 2010, about 20% of the U.S. population age 18 and older spoke a language other than English at home at least some of the time. Among foreign-born persons, nearly 85% spoke languages other than English at home, with Spanish being the most common. English-only policies stand to have a particularly detrimental effect on Latino employees. The EEOC's guidelines hold that broad English-only rules applied at all times are presumptively discriminatory. More narrowly tailored policies applied only at certain times are legal, provided that employers can show their business necessity. The EEOC also maintains that unless employers notify employees of the existence of an English only rule, any disciplinary actions taken against non compliant employees will be viewed as evidence of discrimination. Some courts have held in disparate impact claims that English only rules do not adversely affect the employment opportunity of bilingual employees because they're able to comply with the policy. Consequently, there's no need for the employer to show the business necessity for their English only rules. Courts have also found for employers when the English only rules were not overly broad and rigidly enforced. In one such case, a retail store employee was required to speak English when on the sales floor and in the presence of customers, and expressly permitted to speak other languages in the workplace at all other times. The court agreed with the employer that the policy served the business necessity of promoting customer service and rendering salespeople more polite and approachable. These rulings do not amount to blanket authorization for English only rules. Monolingual employees who speak languages other than English are unable to comply and disadvantaged if the policies are enforced against them. Combined with other forms of hostility to foreigners, rigidly enforced English only policies contribute to hostile environments and national origin harassment. Public employees may be able to assert First Amendment speech rights if their government employers limit them to speaking English on the job. If used at all, English only rules should be no broader than absolutely necessary to accomplish a legitimate business purpose. Enforcement of these rules should not be rigid, and employees must be clearly notified that the rules are in effect. There is considerable evidence that gay, lesbian, bisexual persons face discrimination in the workplace and larger society. What, if any, laws protect from employment discrimination based on their sexual orientation? The U.S. Constitution offers some protection against sexual orientation discrimination, albeit only to public employees. When government agencies make adverse employment decisions based on a person's sexual orientation, those decisions can be challenged as an unconstitutional act if they are not related to a legitimate government purpose. Constitutional challenges to sexual orientation discrimination by government agencies generally have not fared well. Many of these cases have involved government agencies with security or law enforcement missions. Title VII of the Civil Rights Act of 1964 refers to sex as a protected class, but for many years courts have held that protection against discrimination based on sexual orientation could not be read into the act. However, the EEOC has pressed the case that sexual orientation discrimination is inherently a form of sex discrimination, even as the Justice Department has argued to the contrary. While federal law remains uncertain, employees in about 22 states, in addition to the District of Columbia, enjoy protection from discrimination based on their sexual orientation under state law. State laws typically prescribe discrimination against sexual orientation, including heterosexuals, and usually include perceived sexual orientation regardless of whether the person so identifies. Employers must be aware and abide by any state and local laws prohibiting discrimination based on sexual orientation. Whatever their sexual orientation, some people believe that gender assigned to them at birth does not fit their gender identity, and they seek to live as members of the opposite sex. Transgender is an umbrella term that includes not only these individuals, but also people who cross-dress while retaining their established gender identities, and persons with ambiguous or unconventional gender identity. About 18 states in the District of Columbia have laws prohibiting discrimination based on gender identity or transgender status. As with sexual orientation discrimination, claims brought by transgender persons under Title VII used to be rejected on the grounds that any such discrimination is not because of sex. However, this interpretation has also begun to change. Sex stereotyping based on a person's gender nonconforming behavior is impermissible discrimination. In a case involving a firefighter who was subjected to adverse employment actions after he informed his employer regarding his gender identity, the court found that there was sex discrimination in violation of Title VII. A more sweeping ruling in this area was a decision in favor of a woman whose job offer from the Library of Congress was rescinded after she informed the library that she would be transitioning from male to female. The court ruled for the plaintiff under the sex stereotyping theory, but also found that discrimination against transgender person falls directly under the protected class of sex. This is the same manner that discrimination against an employee who decides to convert to another religion is based on religion. Overall, the law surrounding discrimination against transgender persons is still uncertain, but it appears to be shifting in the direction of greater legal protection.